Hello everyone, good evening. Good evening, can we all hear me? Hello, good evening, can we hear me? Okay, I want to believe we can hear me. Good evening, everybody. Welcome to week 4 of the JIIPCC Mentorship and Internship program for the ADR class. We are starting shortly. We expect that more mentees will be joining us shortly. It's already 6 p.m. Please, for Emelda, please, I can see you already on the call. Can you please kindly send a okay? For those mentees that are on the call, please can you send notifications into your subgroups, letting other mentees know that we are starting the session now. All right. Good evening once again, and welcome to class. I expect that we'll be having a full class today. What we'll be treating today, our topic for today is mediation and mediation simulation. Sorry, I'm mixing up the topics, but our topic for today is mediation simulation. And please, I would like to confirm once again if we can all hear me.
Yes, I can hear you.
All right, thank you, Esther. All right, so moving on, I would like to just introduce our mentors for today's class. And while we are doing that, is I also like to let the team or the members of the group who are on call already, let them start getting ready.
Then is your voice is faint, so it's not as it's not loud. Then is your voice is not increase.
Oh, all right. So sorry about that, sir. Can we hear me better now?
Yes.
All right. So sorry about the faintness in my voice. Okay, moving on. Our mentors for today. The first of our mentors for today is Mr. Nyachan Nawan. I will not be wasting so much time reading his profile, seeing that we have read it from week 1. So I'll just read a bit of it and then we'll move on to the next mentor. So our first mentor, like I said, is Mr. Nyacham Nawan, who happens to be the executive director of Settlement House ADR Training Institute. Nyacham Nawan is a lawyer and the principal partner of the law firm M. Nyachan and Co., a law firm based in Kaduna, Nigeria. He is a certified teacher, trainer, and facilitator. He is a faculty member and the executive director of the Settlement House Area Training Institute, SHATI, an institution for the training, certification, practice of alternative dispute resolution. He is also a member as well as faculty member of the Nigerian Institute of Chartered Arbitrator, a model arbitration certification institute in Nigeria. He is a certified dispute resolution specialist and international mediation campus trained mediator, an attorney mediator, a certified mediation advocate, an arbitrator, a certified negotiator, an ADR practitioner, a restorative justice practitioner, and a certified emotional intelligence specialist. He is a certified conflict manager, a certified ADR registrar slash secretary, a holder of mediators academy United Kingdom's certificate in commercial mediation accredited by the Institute of Chartered Arbitrators UK, a medical law enthusiast, an employment and labor law expert, is an accredited labor law expert. He is an accredited and trained mediator with Accords International India and has completed a course to become a Florida Supreme Court certified county mediator in the United States of America. Thank you so much, sir, for joining. We are always happy to have you in these our sessions. You've been with us from week 1 to down to before. We are really, really happy for everything that you do for us and all the knowledge you share. Once again, you're welcome, sir. Our second mentor that we expect in today's class, who was here with us in the last session, is Miss Fry Awasum. Um, MISPA is an arbitration ADR associate at Ames Capital and Associates Limited, Kigali, Rwanda. Awasum is an international arbitrator, mediator, and conflict resolver with 10 years of experience, currently serving at currently serving as branch manager of the Chartered Institute of Arbitrators UK Rwanda branch, performs services with the highest standards of professional and ethical competence and integrity. Awasum has served as tribunal secretary in multiple international arbitration proceedings, specializing in investment disputes, commercial transactions, supply agreements, and mineral resources arbitration. She is currently undertaking her first appointment as an arbitrator. Awasum has 10 years of experience as a policy expert, speaker, and trainer at international and national conferences, summits, and workshops. She 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 has workshop. She has 10 years of experience as operations slash program and projects management expert, best female human rights and democracy advocate in Cameroon, awarded by the Senate of Maryland in the United States of America. Awasum holds a master's and MSc honors in development studies with specialties in gender and environmental sustainability policies, awarded by the Kigali Independent University. Um, an LLM in international trade and investment law in Africa, awarded by the University of Disham, Cameroon, a bachelor's degree awarded by the University of Yaoundé to SOA in Cameroon 2014. She holds many other professional certificates and diplomas in her areas of expertise. We've already read Ms. Mispa's profile last week, so I will not be reading all of it. As you can see, Ms. Mispa is well versed and well educated within this field of ADR, and it's always a pleasure having her in our sessions. She's not currently here with us right about now, but I'm sure she'll be joining us as soon as she can. Our last mentor for today, who has been with us for I think about three sessions now, uh, it's always wonderful listening and hearing from her. That is Miss Omotayo Blessing Uwune. Sorry for still not getting your last name maybe correctly in terms of pronunciation. I'm so sorry about that, Ma. Ms. Omotayo is a highly experienced legal practitioner and mediator with over 15 years of expertise in soliciting advocacy, advocacy, corporate law, and property consultancy. A dedicated professional, she has built a distinguished career in legal research, drafting, and alternative dispute resolution. Omotayo obtained her LLB from the University of Jos in 2008 and was called to the Nigerian bar in 2009. She later earned an LLM from the same institution in 2018 and is currently pursuing her PhD in law. She began her legal career at the Court of Appeal Jos during her National Youth Service Corps program, where she honed her skills in legal research and drafting. Over the years, she has worked with reputable law firms, including Solis Chambers and Leo M. Eby and Co. Um, before establishing herself as a private legal practitioner in 2021, her passion for alternative dispute resolution led her to become a certified mediator with the Settlements House ADR Training Institute. With a strong commitment to justice and effective conflict resolution, Omotai continues to provide top-notch legal advice and mediation services top-notch legal advice and mediation expertise. Thank you very much, Mark, for joining. We are happy to have you in class. So far, I am going through, our list of mentees that we have in class, and it seems we only have Group 1 members here on call. I don't know why we don't have Group 2 members joining in yet. I hope we do get to have them join in and take their simulation. So what we will be starting off with right away is the simulation itself, as is our practice in from the start of the program, where we have the mentees present and then we have reviews and feedbacks from the mentors. We'll be taking the same approach in today's session. In today's session, we'll be having the mentees present their simulation based off of the documents that was sent to them. We hope they have been able to prepare a simulation that they will be presenting in class. And if they are ready, please, for those who will be participating in this simulation, we would like for you to kindly identify yourself, maybe by the indication of hand, turn on your videos, and commence the mediation. So, do we have group one ready and in class? Do we have group one members ready in class?
Yes, we are here and we are ready.
All right. So kindly for those who will be participating, kindly turn on your videos, introduce yourself and the roles you'll be playing, and you can go ahead and start your mediation. You have, I think, 15 minutes for your simulation.
Good evening, Mr. Dennis. Please, do we have to compulsorily turn on our videos?
Would prefer if that could be done, right? But if you are in a place that doesn't allow for that, then no issue. But we would rather prefer that you turn on your video if you can.
Okay, thank you. Because it actually rained here, so the weather is a little bit.
All right, noted. But for those who can turn on their videos, please kindly turn on your video. Okay, please, can we go ahead and start?
Okay, good evening, everyone. My name is Esther Chioma, and will be myself, Emelda, and Amanda will be presenting for group one.
Please, those that are presenting is preferable you put on your camera, and then Dennis, please, you pin them, those the mediator and then the two parties, you pin them so that they will be in the same place together. Do you get me? So Dennis.
Yes, sir, I can hear you. Yeah, I will do just that.
Okay. All right, let them put on their cameras, please.
All right, are we still with us? Please, for those please that can turn on their videos, please can you kindly turn on your video and let's commence. Please, we don't want to waste minutes. Okay. Mr. Nyacham, we have some of the mentees saying that their background is not so good, especially for the ones presenting.
So pin them to one location, pin them together, and then let's start.
I've started that. I've done that, sir. Okay, please, where is Esther? Esther, please, you can take over.
Okay, good evening, everyone.
Yes, good
I will
evening.
be, as I mentioned earlier, I'll be presenting alongside Imelda and Amanda. So I don't know if we are already pinned.
Yeah, you're already pinned.
Okay, Amanda and Imelda, can you hear me?
Yes, we
Yes,
can.
I can hear you.
Okay. Just a moment. Okay. So, good day. My name is Miss Esther Chioma, and I am a trained mediator from Settlement House ADR Training Institute with expertise in workplace dispute resolution. And I'll be facilitating this mediation session between A and B company and Mr. Musa. Now, I want us to understand that mediation, as we must have been informed, is a voluntary and confidential process. So I'm just here to facilitate communication between the disputing parties and allow the both of you explore fair solutions to the dispute. My role is to be a neutral third party and just guide this discussion and ensure that we arrive at a productive resolution process. So before we start, I would like the representative of A and B company to introduce herself, and also for the aggrieved party to also introduce himself.
Good evening, Miss Mediator. Good
Good evening.
evening. Good evening, Mr. Musa. My name is Miss Adama. I'm a human resource manager representing company in Kaduna State called Ada during the session.
Okay. Welcome, Miss Adama. Mr. Musa, please can we meet you? And please tell us how you like to be addressed also.
Okay. Good evening, Miss Mediator. Good evening, Miss Adama. My name is Mr. Musa, an employee of A and B company, and I'll be love to be addressed as Mr. Musa.
Okay. Welcome to this mediation session. Now, you agree with me that if we will have a constructive session this evening, we'll have to observe some ground rules. So, firstly, I would like to employ the parties that they should be respectful in addressing each other. You know, when one person is talking, just wait for your turn. Everybody be given, the both parties be given their turns to speak. Also note that everything that we discuss during this mediation process will be strictly confidential and will not be used against any of you in a legal proceeding. And I would encourage you to be open and honest in resolving this dispute. Also, there should be no personal attacks. Let's just be professional and focus on resolving the issues. And I will also encourage each party to listen attentively while the other party is speaking before responding. As I mentioned earlier, the resolution must be agreed by the both of you. And I'm only here to facilitate discussions and not impose any decision. So I would like Mr. Musa to please just briefly state your position and your concerns in this dispute.
Okay. Good evening, Miss Mediator.
Good
My
evening, Mr.
name
Musa.
is Mr. Musa. Like I said earlier, I'm an employee of A and B company. I made application to A and B company based in Kaduna on March 2020. Then I was interviewed online and I got the job, obviously. I commenced work on
Am I still being
April
heard?
1st, 2020, my former job, which was based in Abuja. However, on the
Mr. Musa,
28th day
I
of
didn't hear
March
anything you said.
2020, the government of Kaduna State, yes,
Mr.
on
Musa,
the
are you still with
28th
us?
of March, yeah, I'm here. Can you hear me?
Yes, we can hear you now.
Yes, we
Okay.
can.
Okay. My name is Mr. Musa, and I'm an employee of A and B company. I made an online application to A and B company on the month of March 2020. Then I was interviewed online and I got the job. Then I was asked to come for documentation and commence work on the first day of April 2020. I accepted the offer and resigned from my previous place of employment because the pay of A and B company was actually higher than the other company, than my previous company. Then on the 28th day of March 2020, due to the COVID breakout, there was the Kaduna State government declared a lockdown for the entire state, except providers of essential services. Due to this, I called the general manager on phone about the development, and he informed me that I should not worry, that I should relax, that the human resource manager will call me and direct me on how I will work remotely. But I did not receive any call for over 8 months from the human resource manager. And throughout the duration of the 8 months, I received nothing, not even 5 naira from A and B company. Because of this, it kept bothering me. I consulted a legal practitioner, and the legal practitioner helped me to write to the company, asking them to pay the arrears salary to the sum of 20 million naira. However, the human resource manager replied to me, telling me that the company will not pay anything to me as I did not work for them throughout the duration of the 8 months. So this is my concern. Thank you.
Okay. Miss Adama, you have heard him. Please, can you confirm that story or just briefly state your position and also your concern concerning this dispute?
Thank you, Ms. Mediator. Good evening, Mr. Musa. My name is Ms. Adama. I'm a human resource manager working in A and B company, Kaduna. I believe from the dispute report and partially from what Mr. Musa has stated here today, he was interviewed for A and B company, to the best of my knowledge, and came in for his documentation on the 21st of March 2020. After which he was to resume work, but prior to the COVID breakout on the 28th of March 2020, he wasn't able to begin work. According to him, he has worked 8 months for the company and deserves his pay of 20 million naira. To the best of my knowledge, the general manager reached out to me and informed me that I should reach out to staff, in quotes, of A and B company on directives of how to work remotely during the COVID period prior to resumption. And Mr. Musa in this place, is not a member or a worker within A and B company. All these cock and bull stories he's giving about getting
Miss
employed.
Adama, Miss Adama,
Yes, Ms. Dieto.
you remember what we talked about, the ground rules. Let's be respectful to our language.
No, leave her to say whatever she feels like saying.
Mr. Musa, please calm down. Please, Mr. Adama, you can go on.
My apologies for my earlier statement. Like I was saying, I will rephrase myself. Mr. Musa wasn't truthful in his stance of employment within A and B company. Hello?
I can hear you, Miss Adama. Mr. Musa, please calm down. Allow her finish, please. You'll be given turn to speak.
Okay, Miss Mediator.
And as to his response on hiring a legal practitioner to represent him, the company got a response, or rather got a letter from his lawyer, to which we gave a response stating that Mr. Musa is not a recognized worker or member of A and B company because we have bylaws stating the rules and regulations of our company pertaining to employment. And Mr. Musa did not adhere to them. So in the first place, I won't actually recognize him as somebody who should receive any remuneration from said company. That's all I have to do.
Okay, thank you, Miss Adama. So if I understand both of you properly, Mr. Musa, you say you are an employee of A and B company
Yes.
and deserves
Yes.
your pay.
Yes, I am. Yes.
And Miss Adama says her position is you are not a member of the company yet and therefore is not entitled to any pay. Now, I would like to ask this question, starting with Mr. Musa. What would be the ideal outcome of this mediation process be for you?
Okay. What I want is very simple. Just to be acknowledged as an employee of A and B company. And for the 20 million naira, which ordinarily I'm entitled to be given to me. Finish, nothing else.
Okay. Miss Adama, what do you say to that? What would be your ideal outcome of this mediation process?
I'm a worker within A and B and also a representative of them for this session. Obviously, I will be looking to advocate for my company's position. Nevertheless, I would also like it to be a win-win situation between the both of us.
Okay. Thank you very much. Now, Mr. Musa, to the best of your knowledge, can you clarify the terms of your employment agreement with A and B company? Was there any offer letter specifying salary, start date, employment terms, or anything like that?
I was given an offer letter and I signed, obviously, accepting the offer. Nothing in the contract of employment. Hello, can you hear me?
I can hear you. Please go ahead, Mr. Musa.
I was given an offer letter and accepted it. So ordinarily, I'm an employee of the company. So I'm really surprised that Miss Adama here is saying that I'm not a member. However, I know why she's worried. She's trying to frustrate me because she wanted to be my side chick, but I refused. That's why she.
Liar.
I understand. She's trying to.
Mr.
I understand. I know her type. I understand, but it's not going to work.
Mr.
It's not going to.
Mr. Musa and Mr. Adama, please, let's be respectful with our language. Let's be respectful, please.
Okay.
Okay, so Mr. Adama, please, can you confirm what Mr. Musa has said concerning his salary, the start and employment terms? Are those things saying true to the best of your knowledge? Were they communicated properly to him?
To the best of my knowledge, Mr. Musa has a very wild imagination, and he's obviously here to tell us stories. But to my understanding, our company has bylaws, and under these bylaws, we have different sections that specify certain things. And during his documentation, which he claimed to have attended, he would have come across such. You will obviously see which has been shared also before this mediation started, like I would say. Our bylaws had been shared, so you can easily go through it. If you can go to page 5, you find our employment rules, section 1, sub A. It
Just give
specifies that.
Miss Adama. Mr. Musa, are you
Okay.
there?
I'm here.
Do you see where she's calling?
Not at all.
Miss Adama, please call this section again so that he could make reference to what you're talking about.
I said in the bylaws, page 45,
think you
you
should read it
find
out.
our employment rules under
Are you
section
there?
1, sub A.
Mr. Musa, are you there?
Yes, I am here.
Have you seen the page he's talking about?
Yes, I have.
Okay.
Thank
Miss
you.
Adama, please carry on.
You see in sub A that contains that every employee of A and B company will be subject to a probation period of 6 months, after which you will be paid said amount attached to your position. And in Mr. Musa's position, he is to be paid said sum 200,000 monthly. And Mr. Musa never worked physically within said company. So how will he believe he merits such an amount?
Okay. Thank you, Miss Adama. Thank you, Mr. Musa. Now, I want to ask again, Mr. Musa. Okay, you already stated that you did not receive any communication from A and B company regarding the remote work and payment. So I would like to know, Miss Adama, please, why was Mr. Musa not contacted for the remote work arrangement
Yes,
while
Miss
other
Mediation.
employees were managed?
To the best of my knowledge, the general manager reached out to me to communicate to other employees, staff in quotes, of A and B company on their
Okay.
schedule of remote work during the COVID period. And I did same. But Mr. Musa, who hasn't worked physically within the company and cannot be considered an employee, probably the general manager didn't consider this fact. So I'll also say I am partially to blame in this. But for Mr. Musa to insist that he is to be paid such a sum is outrageous.
Okay. Thank you, Miss Adama. Mr. Musa,
Yes, Miss Mediator.
do you believe that your past relationship with Miss Adama might have influenced the company's actions?
Of course. That's why she's bent on oppressing me. But she will not succeed.
Thank you, Mr. Musa. Miss Adama,
Yes, Ms. Mediator.
how do you respond to the claim that Mr. Musa was deliberately excluded from the work arrangement because of a personal relationship?
I would like to say that I am very much trying to maintain a professional demeanor for this session. But it seems like rather Mr. Musa is very unstable mentally and he feels wronged for no reason.
Miss Adama, Mr. Musa, please let's calm down. Please let's not forget our ground rules. Be respectful to your language. Thank you very much.
Okay, thank you very much, Ms. Mediator.
Like I was saying, I still maintain my stance on the fact that Mr. Musa is not entitled to any remuneration. But my office has magnanimously decided to reach a terms of settlement if Mr. Musa is open to it.
Okay. Mr. Musa?
Yes, Ms. Mediator.
So let's assume that full salary payment is not possible. What alternatives will you be open to?
Okay. First of all, I need to be verified as an employee, a full employee of A and B company. Then I think, okay, since full salary is not possible, at least 50 million naira. I'll be comfortable with that. 50 million naira. That's not a bad price.
A and B company, will you consider any other form of compensation?
Well, Ms. Mediator and Mr. Musa, for my role within the company, I can actually say that any terms of settlement we can reach here, I will easily communicate back to my company. And for these terms, what I have to offer is 3-month probation rather than the regular 6-month probation and a pay of 10 million naira. Nothing more, nothing less.
That's an unfair amount. Don't forget that I already resigned from my other company. I'm a family man. I have 6 kids, 6 girls. How do you expect me to survive with just 10 million naira? No.
Mr.
That's
Musa,
not. Mm-mm.
Mr. Musa, if you're not satisfied with this proposition, what alternative do you propose? What
Okay.
other offer do you have?
So let's. Okay, I will accept our offer of 10 million, but the probation period shall be for 2 months and 2 months alone.
Miss Adama, what do you say about that?
That's something the company can consider. 2 months and 10 million naira pay. And within the 3rd month, Mr. Musa will be reinstated as a member of our company and he will get his full salary every month.
Okay.
That's okay by me.
Verified member.
All right. So we can say we have reached an agreement. Are there documents that we can send to confirm that so that at the return of work, this resolution can be implemented?
Yes, Miss Mediator. My
Okay.
secretary will
Yes, of
reach
course.
out to you with a correction of the terms of condition and we can all sign that.
Okay. So do the both parties understand and agree to the terms of the settlement reached?
Yes.
Yes, we do.
Okay. Thank you very much. Thank you very much, Mr. Musa. Thank you very much, Ms. Adama,
Thank you, Ms.
for
Mediator.
cooperating
Thank you,
during
Miss
this
Mediator.
process. And thank you, everyone. We are done.
Thank you very much. I want to say well done to everyone. So what that was meant was to give presentation and everything that we have done, give correction, also giving correction and also trying to sort out areas. So I'll be handing over to Mr. Nacha. Mr. Nacha, will tell us over to you. Mr. Nacha.
So thank you very much for that wonderful presentation. Okay. Thank you very much for that wonderful presentation. My colleagues are here. Miss Pa, would you want to go first? Are you already settled?
I'm not yet home, still in the car heading home, but I can intervene if you don't mind.
I maybe you can ask Omotayo to speak.
Yeah,
Then,
since she's still
yes,
there, she can speak before I reach home. In the next 7 minutes, I'll be home.
It's all right. Okay, good. All right, Omotayo, over to you.
Okay. Good evening, Mr. Nanchan. Good evening. Gotten for the moderation. I'm sorry, please. My apologies. And good evening, all. So I would say it's a wonderful presentation. At least we are seeing mediation in practice. That's the difference between being in classroom and then mediating proper. So it's a wonderful one. But I still have some comments still, which I would just like, is just as in their brief comments. Like when the mediator actually wanted to start the mediation, she didn't establish whether the mediation agreement to mediate has been signed, because that's like a foundation. If we know that one of the fundamentals of mediation is voluntariness, and how can we establish that the parties have actually agreed to mediate? That is when agreement to mediate has been signed. So that was not done, and that is fundamental. And secondly, Ms. Adama was representing A and B company. She said she's the human resources manager, but was she mandated by the company to represent it in that mediation session? That's also fundamental, because if she's representing the company, and then maybe at the end of the mediation session, the company says, no, we didn't appoint her to us, then that means the mediation session will actually be a futile exercise. So I think maybe it's important that a mediator also establish whether the person that is representing a company has actually been appointed by that company, so that any decision or any agreement reached can actually be binding on the company. Now, while setting the ground rules, it has also been said many times that it is important when parties are involved in setting the rules, they comply better. So that's why it is encouraged that instead of the mediator setting the rules, is it possible to say, oh, in previous mediation sessions that I have actually been part of or have mediated on, parties have adopted some of these rules. Then the decorum, using respectful language, and taking turns and things like that. So would you adopt same rules in this at this mediation table? And then if you also have yours, you can also add to it. Then they will feel that they are part of those that made the rules, not that, oh, these are the rules that I would like us to be bound by also. So sometimes it's just the way we phrase it so that they can feel that inclusiveness, and then it's also easier for them to also comply. That's when making rules. And okay, I don't know. Okay, and another thing that another observation is that I think when the mediation process was getting heated, I think, was it Mr. Musa that was, so this is Miss Adama was saying Mr. Musa is mentally unstable. I feel maybe the thing was getting heated. So at that time, maybe is it possible to just have like a break Is it possible to have like a break? Or maybe let's have 5 minutes break. Or is it also possible to now say, okay, maybe let's go into caucusing, so that that tension can be can actually be doused? Or is it also possible to just maybe like crack a joke just to diffuse the tension at that time? Not maybe control that maybe that situation, it can actually escalate. So maybe one can just look at it, having a break, a joke, that separate sessions. Those are the few observations that I have, but it's a wonderful one, and well done to the team. Thank you very much for the opportunity.
Thank you so much for that.
Those are just the few observations. I don't know. Can I be heard, please?
Yes, we can hear you. Thank you so much for that. Okay,
okay, thank you, sir. Thank you.
Okay, Mr. Nyachan, back to you, sir.
I think this is great. Miss Pai is still on the way. I don't know, the presenters and the group members, do you have any question in regards to the contributions made? Miss Pai, are you already home?
No, I'm not home, Nachan, but I think I can.
Don't worry. Once you, don't worry. When you get home, let me know so that you can speak.
Okay, all right. Because I didn't want to waste our time that much. But if I can reach home in there, while we do other things.
And you can reach home. When you get home, let me know. All right. So, do you have question in respect of? Hello, can you hear me?
Yes, sir, we can hear you, sir.
Okay, so if you have any question concerning the contributions made thus far, she has raised very important and vital points that you have to take note of as a mediator. Very, very important. So does anybody has something to say or question regarding the contributions thus far? Hello? Can you hear me?
We can hear you, sir.
We can hear you, sir.
Okay, so do we have question in respect to what was stated, the contribution of the first speaker? I don't understand. Everybody kept quiet. Okay, so
Okay, so there's a question on the chat. The question is, in a dispute resolution, other than what is dispute resolution, where either parties get kicked in another language other than English, can their request their names, can their request be granted?
Mediation is party driven, so the parties can agree. At the point of preparation, you want to find out whether the language they want to use, and if they need any form of interpretation, or uh, uh, they will also indicate in the course of preparation. So it's actually important for parties to prepare for the session, and they can agree on the language to be used. They have to use a language that everybody can speak, and if where it is necessary, one party does not understand English, if it is English, you get someone to interpret that aspect for. So yes, it can be, that can be allowed.
All right, so please, do we have more questions for us? We're still taking questions. Do we have questions?
So I'm going to ask question. If if nobody asks question in the next 2 minutes, I'll be the one to ask the questions on anybody. So you have listened to the contributions of the first mentor. So do you have any question, clarification, or you understood the process? Hello? You see, we don't know whether you are here or you are not here. Nobody is saying anything. We've not put on our cameras for us to know that you
Me,
are
I'm on
there.
my way back home, so I'm on a public transport, and the noise there is not funny.
So you put on your cameras when necessary so that we can see your face. We know that you are here with us, but nobody is saying anything.
We can hear you, sir. I can hear you, sir.
I can equally hear you, sir.
And so you made a presentation, and we're asking, they made an input or correction. Do you have a question in respect to the input that was made? Do you understand it? You don't understand it? Let us get to hear from you.
Okay, sir, I have a question.
We are all here.
Can you hear me, sir? Okay, so when he was making the correction, she mentioned that when the mediation process is escalated, that instead of like calming the parties down, we should rather maybe crack a joke or just take a pause. So does it mean that we're not necessarily allowed to just call them to order in that manner?
Omotayo, can you attempt that question? Omotayo, are you with us? Okay. So
Can I
You
speak?
see, who?
This is Amanda, sir.
Okay, go ahead.
Okay. Good evening, everyone. I would like to say that for my role as one of the members or parties rather in this mediation, I appreciate the fact that Ms. Omotayo drew us back to the understanding that parties also have the opportunity to set roles for themselves for the mediation process, not just the mediator. So it won't look as if the mediator is imposing certain rules and guidelines for them to follow. It's a neutral meeting, so they should be able to reach an agreement of what should be said and what should not be said, how and how they should interact and what should be avoided within the meeting also.
All right, thank you, Amanda. Okay, so in her contribution, she made mention of caucusing. You can tell us what you understand by caucusing.
So, before we have question, oh, there's a question in chat box from one from Ayo. There's a question
Okay.
in chat box. Yes, the question is after a mediation session where both parties have each other, one party speak, or one party feel to feel each of their part, each his or her parts of the agreement. How can the other party force them?
Okay. So this is how it goes. You know, when you prepare, when there is an agreement, it means parties have settled. So if parties have settled, you have a terms of settlement. That terms of settlement without more is a contract. That terms of settlement without more is a contract. And so now an ordinary agreement between parties on its own is enforceable. Where, for example, you ask somebody to supply you with 1 bag of rice, that you want to use that bag of rice for wedding, and then the person, you now have an agreement. You say, well, upon payment of 70%, the person will supply you, and then you balance it up upon delivery. If that's the agreement that you have, and it's written and you sign, that agreement is a contract. And that contract ordinarily can be enforced. Because for those who are lawyers, we have a procedure. We call it originating motion or application, where you can go asking the court for interpretation of a written instrument. You are asking the court to interpret, so you can simply go before the court asking, based on the circumstances of this case and based on the agreement of parties dated so which is attached, whether so person is liable to pay or do so and so. That's one aspect that you can take. Then the other one is most of the places we have most of the states now we have the multi-door courthouses, and these multi-door courthouses have they have ADR centers. The multi-door courthouses are ADR centers that are managed by the government. They are court-connected ADR centers. So, and in those centers, you have ADR judges. ADR judges are judges who are normal court judges. They were appointed and given the power to be able to take care
Hi,
of.
Nachan, I'm home. I'm back.
Okay, that's
Jack.
finish answering this question and then you speak. So now when there is an agreement between you and then you take it to the multi-door courthouse, when you take it to the multi-door courthouse, you'll be directed to the ADR judge. And when you get the ADR judge, the ADR judge will endorse that copy. First, you will call the parties concerned, confirm if that is the agreement they have concerning the resolution of their dispute. Having confirmed from both parties or their legal representatives, the ADR judge signs that terms of settlement or settlement agreement, and that upgrades it to a status of consent judgment. As you know, consent judgment is not appealable except on grounds of fraud, among several other things. So if that is the case, the moment you file your terms and is adopted or is stamped as consent judgment, it becomes enforceable as a judgment of the court. So when a party fails to perform its own part of the agreement, you can just go back and initiate enforcement procedures. And most times those procedures are carried out by the machineries put in there by the courts. The bailiff sessions, will take care of that. I don't know if I've answered your question. Did I answer your question?
The person who asked the question is
Ayomide, have I answered your question?
it's no longer.
Okay. All right. So thank you very much, Ms. Pap, for joining us. So sorry for the stress. Now the floor is yours.
It's okay. Thank you very much, Nacha. This is something we are so passionate about. So no matter our best as much as possible to speak, to share knowledge, to share experience, where and when necessary, as our schedules may permit. The candidates, will I call them candidates or say mentees? They tried in putting their theories into practice. And my colleague, the co-mentor, outlined some 3 important parts which the mediator didn't take into account, about which is fundamental, and then also parties. I think she said something about the parties' settlement agreement, which I was about saying something in the way she closed her mediation. I didn't take part in the opening session of the mediation. I didn't join before that time. So I don't know whether the Nachan, the mediator, actually introduced herself very well and set the ground rules very well. Because in every proceedings, just
Not properly
they will
anyway,
hold a
but
preliminary meeting. Exactly, good. So as arbitration, in every arbitration, they hold what we call the preliminary meeting and set down the ground rules. Yesterday, I was on one where I'm a co-arbitrator. We held our first preliminary meeting yesterday. We set down the ground rules, and that ground rules is the way the arbitration is going to be conducted, the way parties are going to proceed, how arbitration at the tribunal we are going to proceed. And so the same thing in mediation, we call it the ground rule.
Miss, but you're
Hello?
muted, sorry.
Yeah, sorry, my network, my Wi-Fi kicked me out. I'm back. So I was saying, as to an arbitration, we have the preliminary meeting. So we have the ground rules laid down by the mediator in mediation. And I heard Nachan was talking and nobody is responding. Please, we are so busy to come and give our time and people are not there to listen to us, or people are doing other things. And in a mentee session, mentees should be able to ask questions and not us just coming and talking. I don't think in a mediation session of this one, a complex case like the one you people handled, and there is no question you have to ask to us, might be for clarity. I always tell mentees, please, we are all learning in the process. So feel free as much as possible and let's learn. You might know these theories, but the practical is a different ballgame. So feel free to ask questions, to make the mistakes. Don't look for perfection, but we look for efficiency and effectiveness in what we do, okay? Because when you are looking for perfection, you make mistakes and you don't see them. And that's where the errors come from. So this is just a reminder on the way forward, because it's not normal that the mentees, I don't know if the mentees are in this house. What are they doing? Are they with us? Something, different engagements, and then we are talking to ourselves and people don't have their video cameras on. All those things, organizers, please, it has to be taken into consideration. So we don't come and be talking to ourselves the same time and all the time. And again, something I want to say, the way the mediator introduces his or herself is key. And when you're introducing yourself, you give your professional experience, might be the number of mediation cases you've handled, might be the different type of mediation cases you've handled, whether workplace, family, commercial, or conflict, community mediation, or it buttresses your expertise and confidence before the parties. And parties can likely feel the confidence and comfort in your hands and allow you drive the process, drive the process. Mediation, where the figures are a little bit much higher, okay? Because sometimes in evaluative mediation, you might likely reach at a decision on behalf of the parties. You see? So in this type of work dispute or employment mediation that we're having today, the mediator misses her role somehow. When Mr. Abubakar's emotions were getting high, my colleague said something, Mrs. Omotayo, she said something. A 5-minute break or a 3-minute break might have helped the situation. And when you take a break, you can either take a break or ask for a caucus as a mediator, where you see your parties, because as a mediator, you will read the parties' problems once the party have submitted it to you. In your mind, what we used to call the mediation or the meditation of mediation, in your mind, you're already meditating like, what are the possible solutions in resolving this parties' disputes? What are the possible agreements in which the parties can arrive at? You are reflecting on these things at your very quiet moment, having read the dispute, okay? And my colleague also said something about the parties. Do they have the capacity? Do they have the local standing? Like the representative of the company, did he or she have the local standing to represent that company and take decision or act in the capacity of that company? That will be binding. So you have to make sure, mediator, before you open your session, you enter into the proceedings, confirm parties representation. Okay, who are you? Are you party? Are you party's counsel? Are you the CEO or the manager? What is your stake, your capacity in that organization that you are representing? Because you might come and waste 3, 4, 5 hours in a mediation, of which there was incapacity. So it is a no mediation. It's just like a no mediation, okay? Because the representative of the company did not have capacity or the local standing to stand and make decisions on behalf of that company. Else, it will just be a report session. He or she will just go back and give a report of what took place in the mediation session, and is wasting your time, especially if you are being paid hourly pay in the mediation. The fees will increase, and definitely we are going to have challenges in mediation practice as not being cost effective. Now, the other thing again that is so important, Madam Mediator, it is your responsibility to do what we call in mediation paraphrasing, okay? When whether it was the company manager or the director gave their terms, you have to make sure that you rephrase them or you paraphrase those terms to ensure that the other party, Mr. Abubakar, actually understood those terms in its legality, the consequences, because in your mediator's mind, you are already thinking of the outcome of the terms of the parties, the offer made by the company. How is it going to help this mediation? Or how is it going to drive the proceedings to a successive mediation agreement? Okay? You have to put all those things in your mind. The next thing to do is also make sure that where the parties are taking a longer period of time, the back and forth, because I saw them doing back and forth. The company said they had said this, they had said this, if they don't want anything, period. And then you would have maybe asked for a caucus. And a caucus, most time you do more of advising. You enter into your advisory role as a mediator because you understand the whole dispute. You understand the practice, you can give advice to the company or to the other party such that you guide your process. You have control of your process. If it's a party's business, but you, the mediator, have control of the process, okay? Else, the parties might control even the process for you. But the agreement is coming from them, but the process is into your hands as the mediator to make sure you have a settlement agreement. And again, some of the rules, today we have the AMA in Nigeria, the Arbitration and Mediation Act. It is your right also to back the legality of your process to even make reference to AMA. Because today with the Singapore Convention, mediation settlement agreements are binding. And we are moving forward. The discussions continues around the world to really ensure the bindingness of mediation settlement agreement. It shouldn't just be a talk and boo story or a kind of a talk and no do session, you know, because professionals have been trained. So people are really advocating for the bindingness of mediation settlement agreement. And again, I think there was one more thing. Okay, good. The last thing I wanted to comment on was on your closing. Madam the mediator, are you with me? Is the mediator here? Madam mediator, are you here? If you are here, you can on your microphone and speak, madam. Madam mediator, are you here?
Yes, ma'am, here, ma'am. Good evening, ma'am.
Okay, all right. That's good. Okay. So I don't know if these points are making some sense to you. Are these points making some sense to you?
Absolutely, ma. Yes, ma. I'm taking notes,
Okay,
ma.
good. And these are actually things that makes us better mediators, and we can compare standard with other mediators of other jurisdiction, okay? And again, the last thing, before you close your mediation session, because you just close your mediation so abruptly, I was able to catch that area. Before you close your mediation session, make sure you give we call it rapport, or a report, or a summary of all what has happened during that session. And you do it by using a question answer or question and confirmation method. Okay, you can use open-ended questions at this level or close-ended questions. Okay, as a mediator, you have to be very careful and cautious that you might say, Mr. Abubakar, can you please confirm with me that we agreed that the company is going to do this, and that? He might say, I confirm, or say she confirms. The company, on the other hand, so haven't discussed several terms. So should I take it down in this mediation session that parties have agreed to do this, that? By the time you do this, you should make a summary of the terms parties have arrived at. It eases you, whether you are the one drafting the mediation settlement agreement. By the time it even reaches in court, the court takes minutes of all the proceedings. I know the proceeding that took place, and the court had to go back to see the manuscript, see the draft of that proceedings, because the court, that one, even it was in an arbitration, it was challenged. The court had to go back to see the proceedings or the draft. You see? So if you use this method in closing your arbitration, or your mediation, it's going to make you more professional, more skilled. This time is not about knowledge, but being skilled. Because there's difference between having knowledge in mediation and being skilled in mediation. So you make sure you use the open-ended or closed-ended questions to confirm everything. It might be 5 terms that have been agreed on. Please make sure you retake these 5 points of a summary, and then as parties agree and confirm, you tell parties to give, might be their last words, because we are looking at the bindingness of this settlement agreement. Parties give their last words. If they have something to add, or they have something that they want to remove from previous discussion, or there's something they want to add that they did not think of during the discussion, you give them that room. If not, you can now close the proceeding by thanking them for opting or choosing mediation, thanking them for trusting in your capacity, your skill, and your experience as a mediator, thanking them whether they were the one who appointed you or it's an institution who appointed you. You make sure you always give that gratitude back. You build trust. You build even your next appointment. Okay? So when you do that, at the end of it, you make sure that if you are the one drafting, you draft the final terms as parties have agreed, send it to parties within a particular deadline, confirm it if it is what they agreed on. If it is okay, you send it again. Just, you can agree if it is virtual online mediation, you send it, people say, there is difference between digital. I don't know if you guys know the difference between digital signature and electronic signature. Who knows the difference? It's very important in online mediation or arbitration or adjudication. Who knows the difference between digital signature and electronic signature? Who knows the difference? Anybody? If you don't know the difference, you feel free, please, to on your mic and say you don't know, or you know, so I can move forward.
Okay, Ma, I think I know the difference.
Okay, go ahead. Who is that, please?
My name is Amanda.
Amanda. Okay, go ahead. Difference between digital signature and electronic signature. Mm-hmm.
Okay. One is an image that is already, well, what if someone has signed on a paper and taken a picture of that image, and
Mm-hmm.
another is a signature that is written on the monitor or on the screen of the phone,
So which
or
one is
signed
which?
rather.
You get a perfect characteristics of them. So which one is
Okay,
which?
the
Which one is
digital will
digital?
be that of a picture, and then the electronic will be that is signed electronically.
Come again?
I said the digital signature will be that has already been signed and a picture has been taken of that signature. And the electronic
Mm-hmm.
one is the signature that has been signed directly on the monitor or the phone.
Okay. You got their characteristics very well, but you have inverted them. Okay. The digital one is that one which, for example, you are using a PDF sign, PDF signature. Okay. And then the electronic one, it is what you have already signed either as a picture, and then you are either sending or you are attaching it to a document. Okay. That's electronic one. And the digital one is the one you sign it digitally. You do it digitally, okay? So you actually understand the concept, but you misplace which one is which. So whether you are signing, you most time parties will want to sign digitally, and then they send it. You make sure that the settlement agreement is signed, and then party can take it for enforcement, especially within the jurisdictions that have ratified the Singapore Convention, and then that becomes binding. But I tell you, if you conduct your proceedings very well as a mediator, you have almost 90% or 95% to see parties abide to it because they voluntarily agreed to mediate. Okay? But if the mediator lacks the skills, then you might not lead the proceedings well and parties will not be satisfied to arrive at a particular agreement or settlement. I think those are the comments I had to make for you guys. I can't make comments for the parties because parties, they can exhibit any form of character in a mediation. Some might even want to fight when emotions are high. It is your responsibility as a mediator to calm down the room, bring down temperatures. Energies are high, you bring it down. You can call for a break, let them go. Might be some mediation rooms even have bathrooms. Some people might be very hot and they say, go and take a shower. You go and take a shower, especially for family mediation couples during divorce. Some will come very hot. You say, go and take a shower. In some mediations, they even have bathtub. You tell the two couples, go and enter in the bathtub, the shower, and you have a cool time. Maybe you might rethink and you might change your decisions about your divorce or about the custody of your children or whatsoever. So it all depends on the type of mediation. It is you who is the master of the proceedings. So thank you, guys. Those are the little contributions I could make for today.
All right, thank you so much, Ms. Mispa, for your contributions. It was very detailed, and I'm sure our mentees were listening and paying attention. So please, kindly in our next session, maybe during the simulation, please, the simulation for arbitration, the group should try to ensure that you are more steady and more stable and in a place where you can turn on your video so that we can easily see you while you are hosting your session. So back to Mr. Nyachamsa, do you still have anything you still want to take as regards to this particular class? Are we still going to be taking in more questions before calling it a day? Mr. Nyacham, are you with us? Okay, so please, if we still have questions, we can please kindly ask. We are still taking questions. If you have any questions that you need a form of clarity on, you can ask questions and In the absence of any question, I think we can say it has been a good class and we can call it a day. So do we have questions? Okay. All right. So I want to assume that we don't have any more questions. So while we are still like trying to round up, please, I would like to kindly ask that for those that have a little bit of lighting in their background, can you kindly turn on your video so that we can take a picture or a screenshot in class and for our social media postings. So please, if you have your videos turned, if you are in a place where you can turn on your videos, please kindly do that so that we can take a quick screenshots. Thank you, Regina. Can we have more mentees turn on their videos? Okay, thank you, Ms. Omotayo. All right, please, can we have more mentees? We've not yet taken our pictures yet. We're waiting for you to turn on your videos. Please, can you kindly comply?
A minute, guys. Let me come on my camera for the pictures.
Noted, ma'am. Okay.
Can you see me now?
Yes, ma'am, we can see you. So we're taking our
Okay.
pictures now.
Okay.
Thank you.
You're welcome.
All right.
It's okay?
Yeah, it's okay. We're done.
All right,
Thank
all
you
right.
very much.
You're
All right,
welcome.
so we want to say a big thank you to all mentees in session and also to our mentors for, the wonderful feedbacks during today's class. During today's class, it was really, really nice getting to see the team put a wonderful mediation together. And it was also wonderful hearing our mentors give feedback, giving feedback to the presentations and also trying to correct, the mediation proceedings. I'm sure the process itself, the corrections and everything are things that we'll take note of to make us better mediators. It is something you can add to your portfolio that you have been involved in a mediation simulation. You know what a mediation should look like, and how the proceedings should go. So, it's something that you are building on your back in form of experience, in form of expertise to make yourself overall a better actor in ADR. So, next week we'll be having a simulation for arbitration, right? In today's class, we had a simulation for mediation. In the next class, we're having a simulation for arbitration, right? The idea is to give you hands-on or put you in a position where you have hands-on experience of what you have learned in class, everything that you have researched and done, right? Now you can practicalize it in a real life kind of setting, and you can take away keynotes and key points, and you can be equally guided and put through where there were mistakes and errors. So please, I would like to kindly ask us to put ourselves in a position where we can learn from our mistakes. If you are corrected, please take it as, in form of constructive criticism, something that you can learn from and something that you can use to adjust yourself within practice. So we come to the end of today's class. Once again, a big thank you to both mentors and mentees in session. For the mentees, please kindly share what you have learned in today's session on your different social media platforms. Tag JIIPCC, JIIPCC, and also tag Shati, that Settlement House ADR Training Institute. Right, the next tax or the new tax ahead of the next class will be posted in your group, I think either today or tomorrow morning. Please watch out for it and also try to prepare on time so that, everybody knows their roles and everybody is in class on time to play their parts. Thank you once again for such a wonderful presentation from the mentees, and thank you to our mentors for such wonderful insights and feedback. We've come to the end of today's class. Good night, everyone, and please enjoy the rest of your evening.